We have the next question here, and this question here is actually it's very interesting because as attorneys we take it for granted that everybody knows this particular term. It's one of the most Afrikaans sounding terms or Dutch sounding terms I've ever heard in my life. It sounds like, you know, when you if I had to say this term now, people probably think, wow, my goodness, he speaks Afrikaans so well. And the term that I'm referring to is Huur Gaat Voor Koop. And you guys hear this all the time, both Cilna and Bruno. But I think our viewers, a lot of them, you know, are not entirely certain what it means. And Cilna, please can you explain to us, what does Huur Gaat Voor Koop mean?
So Huur Gaat Voor Koop, I'm very glad that we're having this conversation, because I think Huur Gaat Voor Koop for us as property lawyers is such an obvious thing. It's like thinking that you have to explain to somebody that the sky is blue, but the truth is that's not the case. Just because we see it every day doesn't mean it's an obvious thing and everybody knows exactly how Huur Gaat Voor Koop works. So Huur Gaat Voor Koop is obviously a Dutch law principle. Remember, the South African legal system is based on the Roman Dutch law system. So Dutch law is very, very relevant in our law. What Huur Gaat Voor Koop says is, if there is a lease agreement in place when a property is being sold, the rental element of this goes before the sale. So if you do a direct translation, rent goes before sale. Huur Gaat Voor Koop. It actually makes sense. So the reason for this is because of the separation of the different rights that we have with the right of ownership. So the right of ownership being the real right. A real right is a right that attaches to a thing. And in this context, the real right of ownership, the right of ownership of immovable property, has multiple little personal rights that forms this right. So it's this collection of rights. And the right of occupation is a personal right that can be traded with completely separately without affecting the remaining personal rights that form part of this collection of rights that form the right of ownership. So that's very important to be aware of. Because this right can be separated out, the personal right of occupation, and traded with separately, when you are then trading with the full right of ownership, the collection of rights, you can sell the property and you can transfer the property to a third party without affecting this personal right. Only when the personal right of occupation, being the rental, comes to an end, will it now fall back to the purchaser, the new owner of the property, and it won't go back to the previous owner, who is the landlord. Very importantly, this happens by way of law. You do not have to do an addendum to change the landlord on the lease agreement. If I am the landlord and the lease agreement says landlord Cilna Steyn, and I am selling the property to Bruno, the fact that after transfer, he's the owner of the property means even though the lease agreement says Cilna Steyn is the landlord, I am not. And Bruno can act in terms of that lease agreement on every single right, and he has every single obligation I had as the landlord now, even though his name isn't Cilna Steyn. We don't have to do an addendum. We don't have to do anything. He is now just stepping into my shoes as the landlord. And this happens by way of law on the date of registration. The purchaser steps into the shoes of the seller. And very importantly, once this happens, all the rights and obligations in the lease agreement transfers to the landlord. So if the landlord, in terms of the previous lease agreement, Well, in terms of the lease agreement, if the previous landlord, the seller, had a clause in there in line with section 4, subsection C, subsection 5, subsection C of the Rental Housing Act, allowing him to cancel the lease agreement midterm, the purchaser of the property will now have that right to execute that right and say, you know what, tenant, it's been firm. I am enforcing this right I have in terms of the Rental Housing Act to do a midterm cancellation so I can take occupation of the premises. So that's very important to know that these two things aren't in contradiction with each other. They are supporting each other, but it's very important to understand the principle of Huur Gaat Voor Koop, both as a landlord and a tenant, and crucially as a purchaser, because a lot of purchasers do not do due diligence on those lease agreements. They do not check if there's a clause in the lease agreement allowing for midterm cancellation. And if the clause is not in the lease agreement, you can't cancel. It's a requirement in terms of section 45C that it's recorded in the lease. And as a purchaser, it's crucial to have a look at the lease agreement with your own eyes. Don't trust what the agent says. Don't trust what the seller says. Get a copy of that lease agreement before you sign the OTP if you do not want that tenant. And if you do want that tenant, even more so, get a copy of the lease agreement and make sure you do a full payment history check on TPN before you take on that tenant. That was a long answer, but it was fun.
Good. It was a good answer. And also, when you say it, it sounds so good. It sounds amazing. It sounds like I could use it when I'm flirting with somebody. It was like, so please just say it for me again.
Am I going to be flirting with you if I say
no, but you say it so I can learn how to say to other people.
If you walk into a bar and you're like, hey, can I get you a drink? Or Huur Gaat Voor Koop. I just don't know if that's going to fly.
Thanks, Hilda, for that, though.